if I can then turn to our second panel of witnesses, and I'm just going to ask the three of our witnesses there to introduce themselves very, very briefly, just for the record, again, for those who are either glued to us on the television or indeed for the transcript thereafter. Who'd like to go first? Pippa, would you like to go first? Ms. Woodrow.
Yes, thank you very much for inviting me to be part of this today. My name is Pippa Woodrow. I'm a barrister at Doughty Street Chambers. I have a mixed practice which includes crime and public law relating to criminal justice, as well as other human rights related fields, including immigration asylum work.
Thank you very much. And I think you've dealt with a number of cases in this field, as
I have indeed. I'm one of the Twitter lawyers asking, as you've been mentioning, what the law's going to be. So yes, I've been doing quite a lot of work in this area throughout lockdown.
Okay. Right. Joshua.
Hello, yes, I'm Joshua Rozenberg. I'm a legal commentator, self-employed, and a non-practicing solicitor, and various other things, but no academic qualifications whatsoever.
Just the odd blog and other things,
Exactly.
Great. And Tristan.
Good afternoon, everyone. My name's Tristan Kirk. I'm the courts correspondent for the London Evening Standard newspaper. I've been with the newspaper for the last 5 years or so, and a journalist for about 14 years now. And I've taken a keen interest in the COVID-19 laws and regulations and how they've been applied.
You're a bit of a rarity, Tristan, to actually be a dedicated courts reporter nowadays.
Absolutely. Well, there are still a group of us. There are less than there really should be. But yes, no, I'm very privileged to have a position doing the courts day in, day out, and really focusing down on that work.
Okay, well, thank you all for joining us this afternoon. So I can start off with Janet Davey. Janet. You need to unmute, Janet.
Yes, I'm not in the chamber. Thank you, Chair. Thank you. If I could just start off by directing the question to Pippa Woodrow. Could you set out the most significant criminal offences in the COVID-19 regulations made under the Public Health Act 1984?
Yes, certainly. As you know, by way of general overview, there's the regulations which you've referred to, and then there's the Coronavirus Act. Most, but certainly not all, of the most controversial offences have been under the health protection regulations, of which I think there have now been 26 versions. There have been, I think, 71 versions of secondary legislation, one form or another, but the primary health protection regulations with which I've been concerned, I think there have been 26 versions. And the main offences will be ones with which, in general terms, we're all fairly familiar now. They create offences concerned with freedom of movement, so restrictions on leaving your home or being outside of your home, or at various times staying away from your home overnight without a reasonable excuse. That is the first sort of broad set of offences. And then, secondly, there are restrictions on the ability to gather in various numbers and for various different reasons. But it has been an offence to gather without a reasonable excuse under those regulations. And the details have varied, but in essence, that's what it concerns. And then more recently, in relation to gatherings from October, there have been specific offences in relation to organising gatherings. So it's been made an offence to hold or be involved in the holding of larger gatherings of 30 people or more in certain circumstances, again, without a reasonable excuse. There are other offences relating to non-compliance with enforcement efforts and the like, and other offences relating to business closures, but those are really the core offences with which people like me who've been doing this work have been concerned, and which the courts have routinely been dealing.
Yeah, could you say a bit about how these offences have been structured, and if there's anything unusual about this?
Yes, certainly. On the face of it, structurally, they don't appear unusual per se, save perhaps in their scope and sort of the extent to which they affect such a broad range of people and are so intrusive into everyday life. But actually, I think there is something in the structure of them and the drafting of them which is noticeable. And it's to do with the framing of prohibiting something without a reasonable excuse. Normally in the criminal law, not always, but normally, that tends to denote a reverse burden of proof. So very often where you see the language of reasonable excuse, most commonly will be familiar, for example, with possession of weapon offences or possession of knives. It is presumed effectively to be unlawful unless the person concerned can demonstrate that they've got a good reason or a reasonable excuse for having engaged in that behaviour. It's not been made explicit under the regulations how that is to be applied in this case and how the burden of proof sits. It's been, I think, the consensus broadly amongst lawyers, and certainly discussions in court in the various cases that I've been involved in have all agreed that there is no reverse burden of proof, that it's for the prosecution to prove all elements of the offence, including the absence of a reasonable excuse. But I think that language has led, in some cases, to confusion and to examples of over-policing at first instance, because what should be happening is the police or others tasked with enforcing these regulations should be refraining and exercising restraint unless there is reason to think that somebody doesn't have a reasonable excuse. In reality, what's been happening is the police, I think, have been, once somebody's out of their home, they feel that they have the power, the right to, at that stage, engage with people unless they are effectively visibly manifesting their reasonable excuse. And that, I think, has created problems, particularly in areas like protest and other activities which engage fundamental rights. So that structural issue, I think, has been an interesting difficulty.
Okay, thank you. Would the other two witnesses like to come in and comment on this?
Not specifically on that, no.
Okay.
That's fine. Tristan?
No, that's fine. I think that's
lovely. Okay, lovely. And if I could direct the next question to you again, Pippa Woodrow. Have all the criminal offences created to deal with the virus been sufficiently clear? And to what extent have the public understood what conduct is prohibited by the regulations?
The short answer to that question is no. I think they haven't been sufficiently clear, and the public have, in large part, been in difficulty. The public, and I should say, those tasked with enforcement, including the police, and at times the courts themselves. It is a basic requirement, and I think the chair has already made reference to Bingham principles of rule of law. It's a basic common law requirement, as well as a feature of human rights protections, that criminal prohibitions in particular must be accessible, and they must be sufficiently certain for people to regulate their conduct and know in advance whether what they plan to do is or is not an offence, and what the consequences are likely to be. And unfortunately, we have seen many examples throughout lockdown which would tend to suggest that the regulations have in fact not satisfied that test. Just by way of evidencing that assertion, you'll be aware, I'm sure, that the CPS have been reviewing coronavirus prosecutions since March of last year. That's been a sort of monthly rolling review, triggered by the very concerning reports of people being convicted for offences that didn't exist or in the wrong jurisdiction and the like. Under the Coronavirus Act to date, 100% of those people who've been charged have been wrongly charged. So I think that's about 250 people who have been wrongly prosecuted. And 100% is clearly a number of some concern. But even under the regulations, there has been, I think, a concerning level of error and confusion. The figures for the latest lockdown period, so looking at December to February, I think February is the most recent figures we have, those show that roughly 25% of people charged under the health protection regulations were charged wrongly. And of those 25%, roughly 20% went on to be convicted. And so I think the figures across the pandemic as a whole, so between March last year and February this year, is about 15% of people who were charged were wrongly charged. So those figures, I would suggest, do tend to suggest that people are having difficulty understanding and applying these laws correctly. And of course, that number doesn't take into account fixed penalty notices, the proportion of which that are wrong are likely to be very significantly higher because there are fewer safeguards. I think the confusion arises for in very general terms, three major problem areas. There are difficulties, I think, with the intricacies of specific offences, but dealing with it in general terms, there are three major problem areas. The first relates to the offences under Schedule 21 of the Coronavirus Act. Those are offences which are specifically directed at and only apply to people who come within the definition of being potentially infectious. And it seems that there has been a systemic failure to understand that. And what we've seen is the Coronavirus Act frequently being used in cases where there's no evidence of somebody being potentially infectious. And that's been, I think, a systemic problem. I don't know quite why there's been a failure repeatedly not to recognise that aspect, but it seems it continues to be a problem. The second difficulty is one that you've already touched on with Sir Jonathan in the last panel. And it arises in part from the way in which these regulations have been being published at very short notice. It's been a consistent feature of almost every case that I've dealt with where there have been legal errors, that the police issuing fines or authorising charges have to some extent been confusing guidance with law. That has been a real problem and one that has come up time and time again. As I say, partly that's because the law has been being published in many cases with hours to go. And so those who have been seeking to understand the law, including those enforcing it, have had to depend on effectively ministerial foreshadowing of what the law is going to be. But what we've seen almost inevitably is that when the law is published, it turns out to be quite different, in fact, from whatever the content of that ministerial announcement was. By way of example, I think the very first press conference talked about 5 essential reasons for being out. I have had cases where people were arrested for not having a reason that came within the 5 essential reasons referred to by the Prime Minister. But in fact, of course, the regulations themselves provided, I think at that stage, 13 reasons that would amount to a reasonable excuse. And that was a non-exhaustive list. And so that's a single example of where guidance and the law have been mixed up. And another reason I think for that has been the language that's been used by ministers. They've spoken very much in terms of the rules, but failing to distinguish between what are legal rules and what are in fact rules or really requests contained in guidance. Other examples, I think, have been widespread confusion about whether there is any restriction on how far one can travel. And there's been very public examples of enforcement of people for travelling where, in fact, they've done nothing unlawful. Social distancing, is that a legal requirement or is it guidance? Police have been making that mistake. The reality is it's guidance and there are no legal enforcement powers connected to social distancing. The amount of time people can exercise has been another very common misunderstanding. And so that, I think, has been a real problem. That's the second one. The third area relates, I think, to a failure of the regulations and the way they have been drafted. And it comes where the regulations appear to conflict with fundamental rights protections. The regulations do not deal in terms with human rights or activities that are protected by human rights provisions. And in some cases, they appear on their face to conflict with rights. So the starkest example are rights to freedom of expression and freedom of assembly, which include the right to gather for the purpose of protest. But there are others, religious freedoms, freedoms connected to political campaigning and political activity. And there is now a very clear body of evidence, including recent findings from the police watchdog in their inquiry into the Sarah Everard vigil, that the police and indeed the public have not been able to understand the law as it relates to protest and other fundamental rights. And that has led to widespread suppression and chilling of rights far beyond what the law actually requires or permits. I don't know if it would be helpful to just walk you through what the law is and why I think there's been confusion, but in essence, the root cause, in my view, has been that the regulations have not been sufficiently clear, and it has required police on the ground to be aware of detailed case law, which in a pandemic is perhaps unrealistic as an ask of officers.
Yeah.
And so that's the third difficulty that I think.
Yeah, no, thank you for that. That's very comprehensive response. I can see you, Joshua, you'd like to come in on this one. Yeah, go ahead.
Yes, I would. If I can really enlarge on what Pippa has said, the place that you would go to try to find out what the law is, assuming you're a member of the public and you don't have access to legal advice, is, of course, the Gov.uk website. And if you go to the main page, which is headed Coronavirus Restrictions, What You Can and Cannot Do, comes from the Cabinet Office, last updated 4 days ago on the 16th of April. And if you were to take the example that Pippa gave and that she knows a great deal about, much more than I do, if you were to take the example of demonstrations, there's no subheading for protests or demonstrations. You look at the starting point and it says gatherings above the limit of 6 people or 2 households can take place only if they're permitted by an exemption, I should say. The exemptions are listed. You look down for other circumstances and it says you may gather for the purpose of COVID-secure protests or picketing where the organiser has taken the required precautions. Now, you as a member of the public would not know whether the organiser has completed a risk assessment. You would not know whether the organiser has taken the required precautions. But the point that Pippa makes about the Human Rights Convention, Article 10, freedom of expression, Article 11, freedom of assembly, that's not mentioned at all in the government's guidance. And yet it's well established, and Pippa was in one of the cases that established this, that these regulations have to be read subject to the Human Rights Convention. And that is why one is entitled to say, surely these notes published by the government for people should indicate the circumstances, broadly speaking, in which it's possible to go on a demonstration, and at least allow people the option of researching it further in order to find out what the law permits.
Yes, Pippa, you'd like to come back.
I suppose the same thing, Joshua, is that the police officer policing the demonstration needs to know as well, doesn't he?
Well, absolutely. I mean, there was an inquiry by the Inspectorate of Constabulary. It reported on the 30th of March. It found an open letter on the Met Police website. Could have spelt out the position on protest more fully by referring to the existence of the reasonable excuse defence and how this requires the police to consider whether people are exercising their human rights under Articles 10 and 11. And as far as I can see, that letter has not been updated 3 weeks later. The Inspectorate found that to the extent the Metropolitan Police had thought its hands were tied by the all tiers regulations, well, that position risked failing to provide enough protection for human rights. The Inspectorate found documents from the Metropolitan Police which showed there was a degree of confusion as to the correct legal position, and so on and so on and so forth. The Inspectorate found a log which was in the Gold Commander's log, which tried to understand how you tie in Article 10 and 11 rights with the Tier 4 restrictions and says that's an incorrect interpretation of the regulations. Now, to be fair to the police, as the inspectorate said, senior police officers are required to demonstrate an advanced understanding of human rights law, and where police officers are faced with making finely balanced decisions in difficult circumstances, it's essential that the law is clear. So that, to some extent, is saying unless Parliament makes the law clear, unless the government makes the law clear, then it's a bit much to expect police officers on the ground to understand the interplay between these regulations and the Human Rights Convention.
Well, I have information here that the chair of the Police Federation in a recent survey showed that 9 out of 10 officers felt the regulation was not clear. So that fits into that. Pippa, I think you want to come back in and then I'll hand it back to you, Chair.
Yes, I absolutely agree with everything Joshua has said, and I was in the case that was concerned with the Clapham Common vigil, and it might help just to set out, I think, what has happened and why it's been so unclear at that stage. Joshua's referred to what's currently on the website, which refers to protests, for example, where there's been a risk assessment and how is the public to know about that. But during the Tier 4 lockdown, there was no mention at all in any guidance or any police strategy documents, including internal guidance, which suggested that any protest could be lawful. All that those documents said was that protest was not exempt. What has happened is the tiered system there were 4 tiers, as we all know, and in tiers 1 to 3 there was an exemption which referred to protest, and it's the one that we have now, which refers to effectively there being a risk assessment and the organisers having a certain identity, but at least protest is mentioned. In tier 4 there was simply no mention of it. The exception was omitted. Now, the police interpretation of that, you may think on one view logically, was to assume that if it's been left out of tier 4, that must mean that the intention of the drafters was that protest cannot be allowed. It can't be lawful, it can't be a reasonable excuse. That is in direct conflict with authority of the Court of Appeal, because in order to provide for human rights protections, to which the regulations must always be subject, there has to be the possibility that protest can be a reasonable excuse. There can be no blanket ban. And so the police were left in effectively rank confusion, as were those who wished to protest but believed themselves to be under threat of criminal sanction. And there has been, I think, nationwide chilling of the rights to protest and indeed other rights, which are of real concern. But that, I think, is what has happened.
Thank you very much.
Might I just go in to add on those points that, as has been voiced there, the wrong laws being used, and I've observed that quite a lot in the early stages of the pandemic. The wrong offences being laws being applied. What is perhaps of a little bit more concern is that the wrong offences are still being applied, and new charges coming into the courts. The Coronavirus Act is still being used to prosecute people, and those cases aren't resolved. There was one just earlier this month in one of the London courts. So it's obviously a concern that the police are perhaps misunderstanding the law. What's maybe is a more concern is that the courts, the magistrates, the judges, and perhaps even the lawyers are still not spotting those cases and pulling them out. And if I might add, perhaps a concern on the other side that people are not only being wrongly prosecuted, but maybe wrongly cleared. I've certainly seen a couple of cases where people have been cleared after offering very little evidence that they weren't breaking the law. So there's a misunderstanding on both sides.
Okay, that's very helpful. The injustice goes both ways. Yeah. Okay, Andy Slaughter.
Thank you, Chair. You've given a very graphic example of what happens when things go wrong, either confusing guidance and law or simply imposing or making decisions that alter violence. But can we go back a step and just look at fixed penalty notices themselves and whether you think they're an appropriate way of dealing with this type of offences, what the pros and and cons of that are. I mean, we've been, long before COVID, as a committee, we've often discussed what the problems of out-of-court disposals are and penalties where there's no judicial intervention. Do you think that is a problem here, and how can it be resolved?
Who wants to come in on that one? Joshua?
Shall I begin? As a matter of principle, a fixed penalty notice is perfectly acceptable. It's a notice offering the person to whom it's issued the opportunity of discharging any liability to conviction for the offence by payment of a fixed penalty, and they've been part of road traffic law for more than 30 years, and where a motorist knows that he or she has committed an offence, it's an opportunity to pay a penalty and avoid a conviction. But as Sir Jonathan Jones pointed out to you earlier, unlike the Road Traffic Offenders Act 1988, which gives the opportunity to the motorist, the person who receives the fixed penalty notice, to request a hearing, there is no such provision here. And again, picking up the points about the fixed penalty of £10,000, a penalty of that size might be appropriate in some circumstances. If you were to organise a mass rally where people broke regulations and put others at risk, well, a court might decide a penalty of that size was appropriate. The problem with a fixed penalty notice, of course, is that it doesn't come before a court as such. You either pay it or you don't. And in some circumstances, it may be the right penalty. In some circumstances, it may not. If it comes before a court, you would expect time to pay. You don't have that opportunity there. And so you have to either take the risk of not paying it and hope you won't be prosecuted. I believe there's a 6-month time limit for summary offences, so you can't be prosecuted for a summary offence more than 6 months after the event. But nevertheless, you don't know for 6 months whether you're going to be prosecuted and convicted and ultimately sentenced to a heavier penalty than the fixed penalty you've turned down. And I would go further than Sir Jonathan Jones and say that it's certainly an oversight. There certainly should be a way in which you can challenge a fixed penalty notice and indicate that it's not appropriate. It is interesting that according to evidence given by Kirsty Brimelow QC to your colleagues on the Joint Committee on Human Rights, there is a practice of defence lawyers approaching the police and saying, come off it, this isn't appropriate, and the police may well decide in those circumstances to withdraw it. But that's a pretty unsatisfactory situation. One needs a formal process.
Yeah.
In some cases with Kirsty and in other cases alone or with others have been involved in trying to develop that effectively informal procedure. What we have been doing is where it is very clear that a fixed penalty notice has been issued unlawfully, we have made representations to police forces inviting them to withdraw that fixed penalty notice. Some forces have been prepared to engage with that process, and where mistakes have very obviously been made, they've been prepared to withdraw those fines, or in some cases to withdraw those fines and reissue fines for an appropriate offence, for example. But other forces have been very resistant to any invitation to review fixed penalty notices, even in cases where they can offer absolutely no substantive justification for having issued a fixed penalty notice and where it is absolutely clear that a mistake has been made. The position effectively has been, the notice has been issued. If you want to avoid paying it, that's entirely up to you. You have an opportunity, you have a remedy, because you can simply go to the magistrate's court and plead your case there. There, as a matter of principle, that is enormously problematic, I would suggest, for quite a few reasons. First, as has been alluded to, as a matter of principle, I would suggest it is wholly unreasonable to expect somebody who has already been subject to unlawful police interference, particularly where fundamental rights are concerned, but in any case, that person should be required to undergo a criminal prosecution in which they are in the dock as a criminal defendant with all of the anxiety, distress, potential reputational risk, potential consequences for their work, all sorts of potential consequences, that somebody should have to elect to undergo that process simply in order to avoid paying something that should never have been given to them in the first place is, I would suggest, problematic. A fixed penalty notice is an offer to avoid criminal proceedings, but it is in many cases a coercive one. And I have had very many cases where people who have acted perfectly lawfully felt compelled to pay the fine, notwithstanding that they'd done nothing wrong, because they simply couldn't take that risk of having to go through court proceedings, enduring the stress, and indeed risking conviction. I've already indicated some of the statistics which indicate that 25% of people who were wrongly charged under the regulations in the last lockdown were in fact convicted. And so having done nothing wrong is not necessarily always a guarantee that there won't be mistakes. It's also a complete fallacy, I would suggest, that electing prosecution in the Magistrates' Court is a way of avoiding a financial consequence, because if you want to be represented in the Magistrates' Court, you may very often have to pay for that representation yourself. And if you're acquitted, you can't necessarily recover the costs of that legal representation, certainly not at private rates. Legal aid may very well not be available. And so you may have to pay to defend yourself anyway. The third difficulty.
Are people represented?
That yes, people are. I mean, I think this is something that you're likely to raise later. But there are sort of two parallel processes. There's a single justice procedure which people can elect, and that usually doesn't involve any representation because it's dealt with in the party's absence. But in other cases where somebody actually wants to contest matters, then yes, they are very likely to want representation, and they can and are entitled to be represented. And so in those circumstances, they have to find a way to fund that representation or rely on pro bono services, which I have provided in some cases. But that's
you have to keep these answers and questions a bit snappier, if you don't mind, everybody, because we've got quite a lot of ground to get through yet.
The only other point that I think is important to raise is that there is no mechanism to provide accountability or oversight for the police having given these fixed penalty notices. The Magistrates' Court can't do that. And so where a mistake has been made, there is simply no consequence for the police.
Well, I know, Tristan, if you wanted to come in, and we were talking about £10,000 fine. That's far, in some cases, I think several hundred of those have been issued. That's far above the level that the magistrates or even the Crown Court would levy as a fine for most purposes. I mean, have you had any cases of that kind?
Yes.
Let me see. We have Tristan.
Well, I have come across a couple of those cases being prosecuted through the Magistrates' Court, and when they've come to the courts, they've tended to stick to the £10,000 level when administering a fine. But I agree that that's a huge amount of money for these offences, and in my personal opinion, if those offences that are deemed appropriate to be considered for a £10,000 fine, which can be a life-changing amount of money for a person, really shouldn't be dealt with by way of a simple fixed penalty notice for two reasons, really. If it is considered to be such a serious offence that kind of penalties, to be considered, then it needs to be treated a little bit more seriously, perhaps with a court hearing. But also, given the confused way that these offences have been dealt with over the months, it's perhaps appropriate to have a court hearing so that some of those problems can potentially be ironed out before any kind of penalty is administered. And can I just add, there's new figures that I obtained this week which say that in London, over the first year of the pandemic, around about £3.6 million worth of fixed penalty notices have been handed out, but only somewhere around £500,000 worth of those notices have actually been paid over the year, which is roughly 15%, which does raise a serious question as to whether the system is working at all.
Yeah, thank you. Finally, then, it does sound, I think you might want to come in, but I've asked my last question, which is, what should we be doing? It sounds like you're saying this should be dealt with by summons and going to court throughout. Is that practical, and how would you like to see things change?
I personally don't have a difficulty with a fixed penalty notice regime, provided there is a mechanism to ensure that those notices can be challenged other than by electing criminal prosecution. I don't disagree with what Tristan says about in the cases where £30,000 up to £10,000 fines have been. In those cases, I think there is a good argument for a different mechanism. But in general terms, fixed penalty notices are fine as long as there is oversight and accountability.
Any other comments?
No, absolutely. The fixed penalty scheme for the smaller amount seems appropriate, and obviously then to court if they don't pay.
Yeah, fair enough. Okay, thanks. Thank you, Andy. James Daly.
Thank you very much, Chair. Can I just ask some factual questions, if that's okay, just to have an understanding of when you say prosecution? I've got figures here which say that since the start of the pandemic to the 14th of March of this year, 94,368 fixed penalty notices have been issued, and there have been 1,345 prosecutions brought under the regulations. Now, just to get an understanding of actual sort of charging rather than electing, out of that 1,345, is that are a majority of those people who haven't paid the fine and have ended up in court or elected to go to court? And what's the sort of percentage of the police actually charging people with something and ending up in court in those circumstances?
I don't mind answering that first off. The process, and I can only comment on the London courts, and there may well be a variety around the country. But what we had was a sort of a first, excuse the expression, a first wave of prosecutions right at the start of the pandemic, where within days of the laws actually coming into effect, we had cases coming before the courts. So that was clearly a case of people who were accused of not following the lockdown being sent straight to court rather than being offered any kind of fixed penalty notice. After that period, which lasted around about six to 8 weeks of prosecutions within a sort of a timely fashion, we then moved to a phase where there were some cases being charged by the police forces, but it was a very limited number, and they often tended to be around protests, demonstrations, gatherings. And then there were batches of cases under the single justice procedure, large numbers of cases that were brought in from sort of September through to December, which actually related to the start of the pandemic, which appeared to be people who hadn't paid their fixed penalty notices, and that were then subsequently being prosecuted. And I think what you can draw from the pattern of prosecutions is that 94,000 odd fixed penalty notices issued, only 1,300 prosecutions, means that there are probably going to be an enormous number of prosecutions still to be brought from people who haven't paid those fixed penalty notices. I don't know the numbers on that, but given the figures I said before, millions of pounds worth of fixed penalty notices unpaid, I think we can expect another sort of a significant number of rounds of single justice procedure prosecutions for people who haven't paid up.
I suppose, Pippa and Joshua. Oh, sorry, Joshua.
No, I was just going to say that, following on from what Tristan said, the single justice procedure, which means that nobody's there, it's simply the magistrate and a lawyer in a room going through case files on a computer. The single justice procedure is fine if you're dealing with well understood offences and minor offences, failure to pay for your transport ticket or something of that nature, where there's no doubt that you've committed the offence and you simply wish to deal with it and get over it and plead guilty. You know what you're pleading guilty to, and that's all fine. It's not suitable for an entirely new area of law where there is doubt as to whether an offence has been committed at all. And that's what we're talking about here. Anybody who simply allows this to go before a single justice, assuming that the case will be considered in detail, or anybody who pays a fixed penalty while thinking that they didn't commit an offence and hoping that this is a way of sort of sweeping it under the carpet, may well regret what they've done. And I suspect that if such a large backlog of cases is due to come before the Crown Prosecution Service in the future, the CPS may well decide to drop some of these cases because of the difficulties of simply proving these cases to the requirement that the law imposes. So in those circumstances, there may be no penalty at all.
Joshua, can I just, will you forgive me for my ignorance? In terms of the single justice procedure, that is not somebody who's received a fixed penalty. That is somebody who has been charged with a criminal offence as such. Is that correct? The difference in the two means of prosecution?
Yes, that's right, in the sense that you may have been offered a fixed penalty, you have declined to pay, so the prosecution process starts, and you may be told, well, this will be dealt with by a magistrate unless you wish to plead not guilty, in which case it'll be decided before a court. And in those circumstances, you need to think very carefully about whether you're happy to plead guilty and allow the magistrate to deal with it. I'm not suggesting for a moment the magistrate would not deal with it properly and in accordance with the rules and the law, but if you've got any sort of defence, then you don't have the opportunity to put that in the single justice procedure.
But the point, I'm terribly sorry, just two very brief questions. The point is that the means of disposal, as we've been talking about, is the fixed penalty, whichever way that's dealt with, that leads to the court. Or is the process like any other criminal legislation or any other legislations from the statute, but you are charged following advice from the Crown Prosecution Service and that way?
Well, I'll defer to Pippa because she knows much more about it than I do, but my understanding is that the police issue a fixed penalty notice because they think you have committed an offence. You choose to pay it. In that case, it doesn't go anywhere near the Crown Prosecution Service. If you don't pay it, then ultimately the CPS have to decide whether to bring charges in the normal way.
If I can shed some light, I hope. Subject to what Tristan's already said about cases basically that have been fast-tracked to court and avoided the FPN process altogether, the journey of a case is this. The police will decide that they reasonably suspect an offence has been committed and will issue a fixed penalty notice. A letter will arrive with that person and will say to them, you have 28 days to pay. If you pay, that will be the end of the matter. If you don't pay, whether you notify us of that really or not, you will be liable to be charged. If you don't pay, the police then have the power to charge you. That doesn't require consultation with the CPS. The police can charge you and initiate that prosecution process. Interestingly, within the CPS review statistics, they perhaps understandably make particular emphasis of the fact that overwhelmingly those cases which have wrongly been charged have been charged by police rather than have been subject to CPS review and charging decisions. So most of the errors are emanating from that process rather than a CPS review and then charging decision process. And one of my recommendations, therefore, would be that given the difficulties we've had with these types of offences, the CPS are the ones that should be making charging decisions rather than having to review and fix things at the end of it when things have gone wrong.
Thank you. That's been very helpful. Thank you to all the witnesses and thank you, Chair.
Thank you very much, James. Maria Eagle.
Thanks. Just to follow on from a couple of things about the fixed term penalty notice and way of proceeding to deal with those accused of doing something wrong here. I just wonder, in your experience, Pippa, how many of the fixed term penalty notices are withdrawn after they're challenged, or those that don't result in a prosecution after the expiry of the 28-day window? I mean, is it more routine that they end up in court, or is it more routine that they don't end up in court? Do you have any sense of that from your experience?
I can tell you what my experience is, although it's necessarily anecdotal. Tristan may have a more sort of global overview of the figures, but my experience has been that where the police have been unwilling to either review and withdraw or review at all in the case of those forces that have been resistant to that, charges have followed. I've not generally had cases where they've refused to withdraw, but then just not followed it up. There is often a delay, but charging decisions have followed. I've got no real insight into why it is that so many fines are unpaid and yet at present remain unprosecuted. But one possibility is that as part of the decision whether or not to charge an FPN having been unpaid, at that stage, it's possible that there may have been a review of whether or not the case merits charging. And it may be that the discrepancy in those numbers in fact reflects a very large proportion of FPNs that should never have been issued in the first place. That is certainly a possibility.
Thanks. So Tristan, do you have anything to add in that respect?
Well, given the way that the cases have and strikingly have not actually ended up in court so far, I strongly suspect that there are a large number of cases that are simply just in a queue, and because of the way that appears to have been approached to prosecuting these through the single justice procedure rather than perhaps through the full court process, they're in an extraordinarily large queue, in with traffic offences, fare dodging, all that kind of stuff, and so it may well be that this is just all sort of backed up and due to be loaded onto a court system that really could do without it right now. It's just to be processed at some point, which is an enormous concern. Because of the single justice procedure and the way that it's actually administered. I think this should be a matter of public concern, is that there are hundreds, potentially thousands of cases of people being accused of these offences going through this system where they don't get the kind of scrutiny that you would expect from a full court hearing. They potentially are not being administered properly, and there is no real opportunity for the media or the public to see what's happening here, which causes a problem of things potentially going wrong, but also it raises the question of whether this system is actually sending the public message that you actually want it to do. This is a public health crisis, and you've got a chance with the courts to send a message that if people don't follow the rules that you want them to follow, then they will face a penalty, a punishment, and a criminal conviction. But what we're talking about here is massive numbers potentially of cases that simply have gone nowhere so far, and so by the time they actually reach a court, that message will no longer be any use.
Well, it's also a bit Kafkaesque, being as that the individuals who haven't paid the fines don't really know whether they're going to end up in court or not, which isn't a healthy place to be. I suppose we do have. They are summary offences, so there is the backstop of the 6-month time limit. We have to be thankful for small mercy. So I suppose. At some point in the not too distant future, we'll be able to see what's happened to all of these cases. Is there anything anybody else would like to add on that point?
Yes, I hadn't realised until Pippa put me right that these cases we're talking about don't go to the Crown Prosecution Service. Yeah. But if I were the Director of Public Prosecutions, I would be making inquiries about this backlog now. First of all, to see how many of these cases are going to be dealt with within the 6-month time limit, assuming that applies as a matter of law. And secondly, getting some idea of whether these are cases that should be prosecuted at all or whether they should be dropped, given the pressures on the criminal courts at the moment for reasons that we all know about. So it may be appropriate for the CPS to take proactive action now to look at this backlog and decide what to do with it without it being dumped on a court, as Tristan says it may well be.
Okay. Thanks. Yeah.
Thank you very much, Chair.
Thank you very much, Maria. That's great. Kieran, you wanted to come in? Kieran.
Yeah, just a couple of points I wanted to pick up on. Pippa Ms. Woodrow, you mentioned earlier in evidence that you thought the right to protest had been chilled and were very concerned by that. I don't know, I struggle to reconcile that with the fact that over the last year, I think I must have seen at least half a dozen examples of protests going on regularly. There might be, at the end of a protest, offences being committed and police action, perhaps after it's gone for several hours. But of course, multiple protests have been taking place the last 12 months. Would you agree with me?
I'd certainly agree that protests have taken place. What I mean by protests being chilled is that I have had very many cases of people who have not gone out to protest, who would have wanted to, and whose actions are likely to have been perfectly lawful, and who have felt unable to do so. And there are many examples of that. I think a really good example, actually, is arose in the Sarah Everard Vigil case. There you had a group of women who'd formed the group Reclaim These Streets, who, acting as responsibly as it is possible to do, reached out to the police, sought the assistance of lawyers, went to court, all to try to find out what the law was and what could be permitted. And at the end of that process, were left none the wiser as to what the consequences of organising that event would be, and felt unable, therefore, not only to organise something, but to even go to the common. And so, despite the fact that some people did, that is no answer, in my view, to the fact that many other people have been prevented from doing so when you look at positive duties under Articles 10 and 11 to uphold the right to protest.
Okay. And then the other point you made about, if you go down a route with the police and they've acted incorrectly, that there's absolutely no oversight of that. Obviously, people are entitled to about treatment by the police that's incorrect. Would that also be accurate?
Sorry, that the connection cut out, I think, at the crucial moment. Could you repeat your question?
You're saying that there's no route for anybody, no route available to anybody who's been treated incorrectly by the police. Would you agree that everybody has the right to complain to the independent body that oversees the police?
They certainly have a right to complain. I think it's a broader issue than that, though. What we've seen is very many examples of mistakes being made, and I think we'd all agree that where there's lessons to be learned, that's something that should be encouraged and facilitated. And there should be, we're all dealing with unprecedented times, unprecedented measures, new offences. And I have, in fact, great sympathy for the police trying to deal with 71 sets of new regulations being handed down hours before. I have all the sympathy for that. And so where things have gone wrong, we should be working together to make sure that they don't go wrong in the future. The problem has been that a refusal to review and withdraw fixed penalty notices. Yes, you can complain to the independent office of police complaints, but that doesn't do anything about your FPN. It doesn't stop the FPN being issued next week, this year, whenever it's going to be. And I'm afraid it just doesn't fix the problem.
Okay. I think it's just important just to make, that it's not they're unaccountable. Just the route through which you see accountability wouldn't be appropriate in your view. I guess listening to your criticisms of FPNs and how they've been used, would it be fair to say that they apply to all FPNs? That is the manner in which FPNs they're issued to you. You can accept them. If you don't want to accept them, there are potential consequences in terms of court costs and other things that might disincentivize you from accepting from challenging them.
No, and here's the reason. In almost all other cases, there is a right of appeal. So in driving cases, you can appeal that FPN. If you lose your appeal, then generally speaking, it will be because your case merits the FPN having been given. And if you still want to challenge it, then fair enough. There are other ways that you can seek to plead your case. What I'm talking about are cases where mistakes have very clearly been made, so much so that public law errors, for example, have been made in the giving of FPNs. And there is nothing you can do about that except submit yourself to a process of criminal prosecution. The reality is, I, as a barrister, if I were given an FPN for doing absolutely nothing that was totally unjustified, I think I would still feel compelled to pay it, because the risk to me of appearing as a criminal defendant professionally would be, unthinkable. And so effectively I've been coerced into paying a fine that was unlawfully given. Many people are vulnerable and are in that position.
Yeah, so I'm just trying to, because you very, very helpfully articulated this position, so I just want to get the detail of what I'm asking. So is that in the legislation that was used to create these offences a specific choice to not allow appeal that is ordinarily available to people?
I don't know whether it was an oversight or a choice, but what I can say is that from very early on within the pandemic, there have been calls from members of parliament, lawyers and others asking for a right of appeal to be introduced. I think there have been reports from the Joint Committee on Human Rights, for example, recommending that. Those pleas have not been heeded. And so I suppose that makes it more likely it's a choice, but I don't know.
So just so I understand it, so you can ordinarily appeal to the police then for them to review it, and that's in legislation, or that's just how the police tend to operationalise it?
So normally there is a legislative scheme that allows for a right of appeal against fixed penalty notices. That appeal is usually, I think, conducted by the authority who has given them, in very many cases, councils and the like. So when you get a parking fine, I don't know if you've ever had one, I've had a few, you can appeal it, and that your appeal may be rejected or not, but you can submit evidence, you can ask it to be looked at. There is just simply not that mechanism here, which is really concerning given the confusion in the offences themselves. Okay,
I understand that. And finally, this is more of a subjective question, but if we to look at the fact that 3/4 of the charges brought under the regulations were found to be correct, in a global pandemic, the whole new level of law being introduced, the challenges of explaining that to everybody, how do we, what would good look like? What's an objective on whether 84% is not good enough, that actually pretty good considering the circumstances? Would you agree these are all quite subjective figures, or conclusions to draw on the figures?
I suppose it depends on your perspective and what you think is a good system and one that is working well. I think personally would have difficulties accepting that a 1 in 4 chance of being convicted of a criminal offence that I've not committed was an acceptable system that was working well. Notwithstanding, of course, there are difficulties, but there have been opportunities, I think missed opportunities, to fix some of the problems that have arisen, both in the making of legislation, the systems in which the way they're enforced, and in the way that we give oversight. I don't think in the circumstances in a liberal democracy that level of error is something that we want to accept. I think we should be striving to do better.
Can I chip in on that? That the system that's been employed, and this might be something to look back and consider, is basically to adopt the same kind of process for enforcing the laws and prosecuting people as you would a speeding offence. And so with that, you've left almost entirely in the hands of the police officers to enforce the law and then to go on and prosecute. And I think that some of the errors that have crept in have been I think we mentioned it before, the complete lack of CPS involvement, and especially with the more serious offences. And so if you are introducing a brand new set of laws, and especially in the somewhat confusing way in which these have been done, is that not quite a sizable mistake to not bring in legal experts to be administering these laws? And the second point I'd make, and this is only my personal view, is that before the pandemic really struck us in late March, when these laws came into effect, it doesn't strike me as unreasonable for there to have been some thought put into a potential legal framework that might be needed, where there might be a chance that you have to tell people, a mass populace, to stay at home, to not do certain things. And so it seems to me you could have set about drawing up a legal framework and creating sort of a basic set of laws so that the police officers and potentially the lawyers and so on and so forth could understand them and start to grapple with some of the potential drawbacks and loopholes before you actually had to bring them into effect. I think they came in on the 26th of March. People were being prosecuted on the 27th of March.
Yeah.
There's no time for understanding there.
Yeah. I think that's a helpful point. I mean, I guess as a committee, we've heard considerably the challenges and the strain on the legal system at the moment, and including the CPS. And so I guess what you could argue is actually, is it a lesser of two evils that actually we have a whole load of fixed penalty notices, which actually we don't know, the vast majority of which maybe have been properly issued for a wide range of minor offences, that actually at the CPS at a point where it is facing considerable delays on making decisions on very serious offences, is it the time to add on to their workload 100,000 fixed penalty appeals, getting them to review everything the police have said about them, etc. I think that's the challenge, isn't it?
Yeah, fair point, isn't it, Pippa? Unreasonable to overload the CPS when they've got so much more.
I think there are the 2 points that I'd make. First is that when we're talking about CPS resourcing, we have to recognise that it's already been deemed necessary and appropriate for the CPS to be reviewing all of the prosecutions after they've happened, because so many mistakes have been made. And so why not put the resources earlier on to prevent the mistakes being made, rather than having the resources deployed later on if those resources are necessarily appropriate?
Well, I guess if I might say, people don't expect necessarily at the outset when planning. I think you hope that will understand the laws and implement them correctly. But it's a valid point.
Okay. Absolutely. I think at the point at which it became clear that the CPS were having to review them afterwards, at that point it might have been advisable to say, well, should the CPS have been involved at an earlier stage, so that those any issues could have been remedied. The other point that I think just finally on kind of volume is that I'm sorry if I'm repeating, but that the prospect of an internal appeal would, I think, weed out a vast majority of those cases that are obviously unmeritorious. If you take the 15%, which is across the whole pandemic, the rate at which wrong charges have been brought, either by the CPS or police, if you take that 15% figure and transfer it to FPNs, which is likely to be a very much an underestimate, we're talking about over 10,000 wrongly issued fixed penalty notices. If those were weeded out in an appeals process, which would take no resources for the CPS, then we might be able to get the CPS involved in respect of a lesser number of cases where their expertise was really needed.
Yeah, I mean, I guess I think the uncertainty in these types of scenarios cuts both ways, though, doesn't it? Because if you have a population that are operating under a whole new set of rules about which there is uncertainty, and you send out a clear message that, give it a go, we're not really sure, appeal, that has consequences too. People shouldn't feel that we shouldn't, as legislators, fail to recognise the real world consequences of things like that. But recognising that obviously we would always want people to feel they could appeal when they legitimately felt they had a right to. That doesn't mean we can ignore the possibility that in a scenario where everything was very uncertain and everybody could appeal, that it would encourage people to really try their luck. I think that would be my concern.
I think if there are going to be chances, then they're people who will simply just not pay, and then you've got to deal with them in court. And so I think probably it's a slightly false economy to suggest that giving an appeal would reduce workload. I think actually it's probably in the end likely to have saved workload. But there's also, I think,
can I just
I think we're in danger of getting onto a very lengthy debate here.
Yeah, I think 40,000 people
both sides, frankly,
at the end would be tricky.
Yeah, but can I put just a general point to the panel? You've been critical of it for a lot of reasons, but maybe a lot of us are lawyers. Isn't there an argument perhaps we're being a bit purist about this, and that in reality there's an overriding public good that sometimes means you have to move at speed, and lessons, as you've all observed, may need to be learned. But it would be surprising if there were not elements of frailty in the system. Isn't that perhaps the reality that we have to grasp with? What's the response to that?
Yes, that's
Joshua?
right. But on the other hand, the system should be able to deal with those frailties. In fact, despite the efforts of Pippa and her colleagues, the courts, at least in England and Wales, have not really caused any problems for the government at all in terms of these regulations. There have been very few successful applications for judicial review. There was one in Scotland, which Sir Jonathan Jones referred to. This was about the fact that you weren't allowed to assemble in a church. The court found against the Scottish government there, but even that wasn't a problem because by the time the judgment came out, the regulations had changed actually on the day. So the courts have been very accommodating. And I think so have the population been accommodating. But that doesn't mean that it's not possible to manage a system and find ways of dealing with the ways in which it's gone wrong and putting them right. And I think that is the responsibility of the police. It is the responsibility of the Crown Prosecution Service, and it is ultimately the responsibility of Parliament.
Yeah, okay, fair. I think it's been nodding around that.
I think
we've covered.
I'm sorry, if I could just dip in there, just an extra point is that I as a court reporter, I didn't set out to find fault with the system and to find problems with it. When the laws were brought in, I saw it as certainly an interesting opportunity to see how a new set of laws would be applied and how the courts would fare with it. And I think one of the issues is certainly in these kind of circumstances is if you're trying to enforce a law, you're trying to bring new regulations in, you're trying to encourage millions of people to actually stick to the law and to follow the guidance they're being given. The issue is that those frailties, when they start popping up so regularly, is it starts to undermine the message that you're trying to get across there. And so as a court reporter, you go into it thinking that there might be various interesting stories of lockdown breakers or of what people have been doing wrong, and then all you're finding is things that are going slightly awry, and that tends to undermine the.
You don't want to undermine the credibility of the system, I'd say. Yeah. Okay.
The other people who I think have suffered are the police. They require the confidence and the trust of those of those communities in order to do their jobs, and where they have been making errors that were avoidable if the systems had been in place so that those problems weren't so acute and they weren't put in the positions they were put into. Those errors have consequences for trust and for confidence, alongside perhaps there's some examples of powerful people being able to avoid compliance in a way that other people have not. All of these examples of problems, as Tristan said, undermine. The only final point that I think is really important to make is about media scrutiny and openness. It should be emphasised that from the very beginning, these issues only really came to light because of Tristan and his colleagues, shining a light on these things, it is only really with their assistance that any of this really has come. We've been able to have these conversations, learn these lessons, and make improvements. The CPS review is a really welcome light being shone on some of these issues, and it's provided an opportunity for learning. My disappointment is that there have been very many opportunities to fix things as we've gone along, recognising the frailties that were perfectly possible, and we haven't always taken those opportunities, and we could have done.
Okay. Just two very short topics I wanted to wrap up with. One is the provision in the police crime and sentencing courts, which flows from some of the pressures of the pandemic on the Crown courts. And that's been the issue with jury trials and how you manage social distancing and so on. And I think, Joshua, you picked up in your blog the fact that there's provision in the bill that's currently going through Parliament to enable virtual or remote juries. Now, that could be in consequence of the pressures of the pandemic. The legislation could be more open-ended than that. Do you see any particular consequences as far as that, or concerns that rises? We may all have a number, but it'd be interesting thoughts. quickly on
The
that.
first point to make is that remote juries are operating in Scotland very successfully. Yes. They sit in cinemas in Glasgow and Edinburgh, and the proceedings are piped in. Now, they have 15 people on their juries in Scotland, and it's been difficult to arrange for social distancing. This works, but the government thinks it's quite expensive, and of course it is. What I can't immediately understand is how remote juries would help reduce the backlog of cases awaiting trial. Now, the government, in its impact assessment, says that by allowing hearings to be heard in smaller courtrooms, it'll reduce pressure on the criminal court's estate, and this will lead to more efficiency. Video hearings will provide increased flexibility. But I can't quite see why we should need remote juries if social distancing is no longer required. And given that this bill will take a year to go through Parliament and to be brought into effect, we hope that the need for social distancing won't be there. Perfectly reasonable to have it as a contingency should a pandemic return. But I don't see quite why having the jury in one place and the trial in another, requiring you to have two courtrooms, is actually going to help bring down the backlog, as I say, once that's the case. So I don't think that's there are other concerns about some of the government's proposals on that, but perhaps you don't need to go into that now.
Fair enough. Okay. If there's anything else, any other questions around that, then I will give the last question to Butler.
Thank you very much indeed. Mr. Rosenberg won't remember this, but many years ago when I was a trainee BBC reporter, I sat next to him in a courtroom and learned from the master on how to do court reporting. I went on to do other things, and he's probably stayed on the right side of all of this. And so I just wanted to finish off today with a question to Joshua and to Tristan about reporting of cases and open justice. We know that the new Police Crime Sentencing and Courts Bill contains provisions to enable remote observation of criminal cases after the end of the pandemic. And I wonder how you each think that will affect open justice, it will affect reporting, it will affect public awareness of what goes on in our courts. And maybe if I can, therefore, out of respect for a former colleague, start with Joshua.
The system has worked quite favourably over the past year in the sense that you don't have to go to court to report a case. And that's very convenient. You can sit at your desk anywhere in the world and you can follow what's going on in court. You can live tweet, you can report and so on. You don't have the advantages that you get in court by going up to the parties and asking for copies of skeleton arguments, and of course by talking to the parties concerned to the extent you can, although the Press Association has managed to make arrangements whereby the pleadings in some civil cases are distributed to journalists wherever they may be by email, and that's worked very well. So it is possible for the system to work effectively, but that depends on those concerned understanding the needs of journalists. I think the courts have worked extremely hard. I'm talking mainly about the civil courts, but to some extent the criminal courts as well, to enable the media to cover cases. But it's absolutely essential that if cases are to be heard remotely, that they're open not just to the press, but to the public. There was a particular case where a judge said, right, this is going to be open to the public, but if the public had known that it was open to the public, it would have overwhelmed the system. And so we went to some lengths not to make that too obvious. It is a work in progress, but it's very important, as you say, that open justice must be ensured whatever way justice is done.
Just before I come to Tristan Kirk, I just wonder if that's almost a backdoor route to having televised trials, though.
Personally, I'm against televising criminal trials because I think that the pressure on witnesses would be difficult. I'm very much in favour of the proposals which I think the government's accepted but not yet brought into force, whereby sentencing remarks are broadcast. I think that the arrangements for civil cases should be extended to the divisional court, which is, for example, where Gina Miller's 2 cases were heard. There's no doubt that the Supreme Court cases were much better understood because they were televised, but the divisional court is not televised. Court of Appeal is, and this was in effect the High Court and the Court of Appeal rolled into one. So I would extend televising of the courts to these cases, these big judicial review cases, which aren't going to go to the Court of Appeal. They leapfrog the Court of Appeal. So I would extend televising the courts, and if it's possible to have all appeal courts online, which is something that the Court of Appeal Civil Division has been trying to do, then that's great. You wouldn't need all the arrangements for the press. But there are limits, I think, to the extent to which you want to televise criminal trials.
But I guess what I'm getting at is if you're allowing remote observation of criminal cases by the public as well as by journalists or commentators such as yourself, if, for example, you're still not allowing the public into a public gallery, isn't that by default becoming a televised trial?
It is, and that works, but only with a limited number of cases. There are only 2 courtrooms in the Royal Courts of Justice which are available for live streaming. The others require a chap with a trolley with a computer on it to wander around from court to court and switch on the cameras and put them up on ladders on the back of the court and so on. So that sort of technology isn't available, and that there are restrictions. The judges are rightly concerned about recording of proceedings. It's against the law, it's contempt of court. They're very worried that this would damage the proceedings. So it's not quite as simple as saying every case should be open, but on the other hand, if there were more resources into enabling every courtroom, at least in the Court of Appeal Civil Division, to be viewed by the public, then I think that would be a very good step, and it would save us a lot of bother, and it would certainly lead to greater understanding of how the courts operate and greater open justice.
Thank you. And Mr. Kirk, what are your thoughts about provisions to enable remote observation and the impact on open justice post-COVID?
Thank you for the question. Joshua's right that there are some journalists who will be dead against remote observation of cases, and the benefit of being in court is clearly there. But for me, there's a huge opportunity that this pandemic's thrown up to embrace the idea of remote observation of courts, digitizing of the system, so that journalists and potentially the public as well can follow more cases, have more engagement in the law, in how the courts are working. We've been forced into using the technology to keep the system working, to ensure there is a degree of openness. And what we need to do now is not fumble that opportunity to say this worked actually rather well, whereas before the pandemic, judges would have probably turned around and said, no thanks, we're a little too cautious for that. Let's have a bit of a think about it. But actually, we were forced into it, and it turned out that there was actually quite a lot of benefits to the system. That's not to the detriment of actually turning up to court for the big cases, for the trials. What I'm talking about is the smaller hearings, the plea hearings, the first appearance in the magistrate's court, potentially even the sentencing hearing. Now, when you ask the question about televising trials, I'm very keen to not get the two issues mixed up together and it become one big idea, so that anybody looking at the idea of remote observation would think of the idea of televising a trial. They'd be drawn into the American court system, and then suddenly you'd get the idea that maybe we should just stick to what we had before. There are enormous benefits to using the remote observation technology for the smaller hearings, for the administrative process, for the magistrate's court, for you to dip in and out, so that you can cover more of the court's system. You can potentially open that up to the public, so they could perhaps see a sentencing hearing or a first appearance in a case. But I think we're quite far away from allowing mass public observation of a criminal trial, and I don't think that's really what's on the cards at the moment. So yeah, so I think we really need to look at what's gone right, hold on to it, and that will enable more journalists to become, as we said right at the beginning, there are less and less of people like me. Well, perhaps a newsroom that's a bit overstretched could say to one of their journalists, well, why don't you dial into the local magistrates court this morning, have a go at that? And whereas they might not have made that, I don't know, long journey down to the court, they have their court experience through the remote observation. So there are huge benefits, and I'm willing to bang the drum as long and as loud as I can for this, because what I fear is that the judges and the courts might, when this pandemic is finally thankfully over, might find themselves falling backwards into their old routines where they say everyone must come along, everyone must be in the room. And you've got to ask yourself, well, why? Why do they have to? If there is this opportunity, you can use the cameras to expand the courtroom. Where there is a high-profile case, a high-profile hearing in the High Court that lots of people are interested in, you could potentially have hundreds of people watching on a judicial review that affects, say an environmental cause, where you have hundreds, potentially thousands of people who are actually interested in what's going on in that court, and they wouldn't in a million years be able to fit into the courtroom. Those are big opportunities, and I hope that through the provisions that have been set down in the law, the government will take that opportunity to have discussions with the courts, with the judiciary, and to make sure that it's a fundamental part of the system going forward. It's the 21st century. We should really be using the technology that we have. I mean, look at this meeting we're having now. This is something that you could potentially embrace in the future as well. So the court shouldn't be different to every other part of society, in that they say, well, we have the digital technology, we have the cameras, let's use it.
Thank you very much indeed. You've been banging the drum loudly between the two of you, so thank you both. Thank you, Chair.
Great, thank you very much. Unless there's any other questions, I don't think there is. Well, thank you very much on that consensual note and a positive note too. So thank you very much to all three of our witnesses for this panel, and to Sir Jonathan in the previous panel. Great for your time, for your evidence, and the session is concluded. Order, order.
The proceeding has ended.